Well, let's begin. Welcome, everyone. I'm so glad you all came out on this stormy evening. What are the chances we'd have a second winter storm this Wednesday evening, having canceled our first Indigenous science talk of the term due to snow day in mid-January? So special thanks for coming out. And to Lucy, who I'll introduce shortly, was cooling her heels in the San Diego airport for like 12 hours yesterday as flights got canceled. Anyway, but to start properly, I would like to acknowledge that we're gathered today on the traditional, ancestral, and unceded territory of the Musqueam people. Traditional marks the fact that these lands have been home territory of the Musqueam for millennia, something the Musqueam have always known, but as I understand it, archaeologists have had to learn the hard way over some decades of reversing assumptions. Ancestral recognizes that these lands have been handed down from generation to generation according to Indigenous law and traditions of self-governance that safeguard its health and that of all connected to it. Finally, unceded means, self-evidently, that these lands were never turned over to the Crown by treaty or any other agreement. In the context of all the presentations in this series, but especially today, this land acknowledgement is by no means a formality. I'm a great believer in certain kinds of formality and ceremony. I don't think saying something's formal trivializes it, but it's particularly salient and important as an introduction to today's panel. The ambition of the Indigenous Science Research Cluster that in the background is organized this series has been to take up the calls to action set out in the 2015 Truth and Reconciliation Report, to act on commitments that are articulated in any number of memoranda, for example, with the Musqueam, that is UBC Musqueam Memorandum of Affiliation, strategic plans for UBC, most recently 2018, formal apologies that UBC has made to Indigenous people and to the Musqueam 2019, in which UBC has made it an institutional priority to address the legacies of colonialism as they continue into the present. And when you read these statements, the consistent themes are, for example, that addressing these legacies involves working to ensure the implementation of UNDRIP, the implementation of Indigenous peoples' human rights as articulated in the UN Declaration on the Rights of Indigenous Peoples and other international rights law. That comes from the Strategic Plan 2018. And more locally, to partner with Indigenous communities on and off campus, I'm quoting here, to ensure their access to meaningful education, to co-develop knowledge through research partnerships that benefit Indigenous peoples, and to build relationships that will ultimately, I would hope, reconfigure, this bit is not a quote, reconfigure the university as a whole. The statement of apology made by our president, Santa Ono, on behalf of UBC when the Dialogue Center opened a year and a half ago, especially emphasizes what he referred to as the depth of culpability of institutions like UBC for the, again, I'm quoting him, stark history of oppression and exclusion perpetrated specifically in this case by the apology had to do with the residential school system. And for the impact more broadly that this history continues to have alongside all the related eliminationist policies and practices of the settler state that are vividly on display in the current Wet'suwet'en standoff up north. The issue is Indigenous sovereignty at a juncture where, as Jody Wilson-Raybould has recently reminded readers of the Globe and Mail, Indigenous people are, she says, at a profound, she's quoting here herself from some years ago, I gather, at a profound period of transition and nation building or rebuilding, a transition from an imposed colonial system of governance under the Indian Act to Indigenous self-governance. In presenting the apology, the UBC policy, Santa Ono calls on all of us to rethink our actions and relations, to find ways to turn a commitment to seek a way forward into meaningful action. He says it's our duty to act. But what exactly does this mean in practice? This session, titled Reconciliation, Transformative Justice in the Ideal, in Practice, and in Comparative Perspective, is meant to interrogate these commitments, to ask what reconciliation can and should mean in a Canadian context broadly, and for those of us who work and study at UBC more specifically. We're honored and grateful to have 3 speakers this evening on this panel. First speaker will be Glen Coulthard, Yellowknives Dene, a colleague here at UBC, just down the hall from me, in fact, in the Buchanan E block, should you happen along that floor. He's in critical Indigenous studies, is, I'm sure you all know, an influential and incisive critic of the rhetoric of reconciliation when it makes recognition an end in itself, an empty gesture that dissociates past harms from present injustices and changes little of substance in the lives of Indigenous people. Following Glen, Eldon Yellowhorn, Piikani Nation, comes to us from Simon Fraser across town, where he's based in the Department of Indigenous Studies. He established this department in 2012. It was then named First Nation Studies. As an archaeologist by training, he is actively working, in addition to archaeologically related work, he does a lot of creative work finding ways of revitalizing and preserving the Blackfoot language, of which he is a native speaker. And he's been directly involved in seeking restorative justice for Indigenous communities whose children died in the Indian residential schools. And then finally, Lucy Allais, a philosopher, indeed a Kant scholar, high church philosophy, I would say, hails from South Africa, spends half the year at the University of Witwatersrand and half at UC San Diego. She's, in addition to writing on Kant, she's published widely on forgiveness, compassion, and punishment, including essays on restorative justice informed by reflection on the successes and failures of the South African Truth and Reconciliation process and commission. So the plan is that each of the speakers will say a piece, about 15 or 20 minutes. I thought, depending on how that goes, I thought maybe I would give you each an opportunity to respond to one another, like if there are themes you want to take up, and then open to a moderated discussion with the audience as a whole. Great. So, welcome to Glen. Yeah.
Thank you. I didn't prepare much. Actually, I'll just leave that down. So, in kind of being provided the task of speaking to reconciliation tonight, I kind of struggled over the last couple of days to think of something original to say. As was stated in the generous introduction, I don't think too highly about the rhetoric of reconciliation, but I also realize that as somebody who has a mom who went to residential school from the age of 3 because she was in an infirmary that was attached to a residential school and then just channeled into the system and went till she was 16 and a half. I recognize the importance of certain gestures that certain approaches to the language of reconciliation, how it resonates with people across different sort of approaches. So in order to get a sense of what reconciliation means, in order to get a critical grasp on it, I think it's important to distinguish the differences in how it's used, depending on who's using it. So I start addressing this in a book that I had wrote when I kind of put some thought into this, and it seemed to me that reconciliation was being used as a language of description, but also with normative import 3 ways. 2 which are dominant within Indigenous communities, the first being reconciliation as a form of healing. So it is important, for instance, for my mom and her family that went to residential schools, that there be a public acknowledgement of some harm that was caused, some violence that was inflicted, and in order to provide some sort of means of coming to a form of restitution and closure based on the internalization of that harm that was caused by Canada. So reconciliation, like I said, in this sort of context is usually referred to as a form of healing, a reconciliation of oneself with oneself in the wake of this violence. The second way that I think it's dominantly used by Indigenous actors or parties is to think through reconciliation of some damaged or estranged or violent relationship. So this is the language that's usually invoked in policy proposals and recommendations that highlight the normative import of a nation-to-nation relationship. So reconcile a relationship that has been structurally determined and influenced by inequality, violence, poverty, and all these sorts of things in the form of some sort of renewed relationship that emphasizes equality, sharing, reciprocity, and so on. So reconciliation in terms of political relationships. This is entirely different than the way that the state thinks of reconciliation and is articulated both in policy but also in law through recent Supreme Court and other court rulings, including the one that was delivered yesterday or the day before yesterday regarding the Trans Mountain Pipeline. The understanding of reconciliation here is drawn more closely to what is actually the definition or one of the definitions offered in the Oxford English Dictionary, and that is rendering two things or disparate things consistent. In the case of Canada, what is rendering or being rendered consistent through its articulation and imposition of reconciliation as a discourse is the existence of Indigenous peoples as sovereign nations with the presumed and supposedly superior sovereignty of the state. And why is this reconciliation important? Because reconciliation is fundamentally articulated within these circles as an accumulation strategy in colonial capitalist countries like Canada. So I'm just going to quote my one quote here. The way that reconciliation is understood by Canada's Supreme Court, which was leveled in Vanderpeet in 1996, says what Section 35(1) does is provide the constitutional framework through which the fact that Aboriginals lived on the land in distinctive societies with their own practices, traditions, and cultures is acknowledged and reconciled with the Crown. Sorry. The substantive rights that fall within the provision must be defined in light of this purpose. The Aboriginals' rights recognized and affirmed in Section 35(1) must be directed towards reconciliation of the pre-existence of Aboriginal societies with the sovereignty of the Crown. Now, the question that I've asked and continue to ask and see no difference in terms of previous examinations of this is how do you reconcile those two polar opposites? And the way that Canada has, through negotiations, through the courts, and through its public policies, is to deny that Indigenous peoples have anything akin to sovereignty to begin with. Indigenous peoples do not have the right to self-determination. They do not have the right that would trump decision makings by a foreign entity on our territories, which would enable freedom and self-determination between us, our neighbors, and the land. What we are understood as having is cultural rights. So certain rights that the state deems from its own perspective that we are seeking recognition and protection of when we engage in these negotiations, legal or political or otherwise, with the state. We may have certain rights to protect languages deemed important. We may have certain treaty rights that are deemed important but narrowly construed. We may have rights to hunting, fishing, certain subsistence practices, but the state, both in terms of its negotiation and approach to claims, like land claims or modern treaties, or in its approach to these questions as determined through the courts, is an understanding that these rights have to be squared within the framework of a supreme and racistly derived assumption of state sovereignty and within a capitalist mode of production. This is what the Dene, my own community, learned firsthand politically in attempting to negotiate with the state over land rights after after both the Coulthard decision and a lesser known decision in the Northwest Territories called the Paulette case, which put a legal marker of uncertainty over the territories in question, both in the Northwest Territories and BC, and attempted to reconcile that with Canada's sovereignty and its demands in terms of accumulation through extraction and other forms of industry by saying what you need is a cultural recognition and not recognition as political nations with the right to freedom, decolonization, and self-determination. This has even been more emphasized in recent approaches as dictated by the courts. So in Delgamuukw versus the Queen, for instance, We usually see that or understand that to be heralded as a victory for First Nations, when in the end, what it does is says, again, entrenching an inequality between, against the nation-to-nation view, that we should be looked at as co-sovereigns on this territory. The understanding that Indigenous rights can be infringed upon based on previous precedent for a whole host of public goods. Initially in Sparrow, that public good was an innocuous and fairly benign commitment to infringement based off of things like conservation. But by the time you reach Delgamuukw, every imaginable economic activity that would be deemed in the national interest are posited as things that potentially could lead to the infringement of constitutionally protected rights of Indigenous peoples, including infrastructure projects, including pipeline projects, including mining, forestry, and the settlement to produce these aims. So you see that reconciliation as the means of rendering consistent Indigenous claims to nationhood with Crown sovereignty has demonstrably been shown to be in the interest of state sovereignty and its accumulation strategies. And the recent decision yesterday, I think it was, which showed that the First Nations in the right-of-way that were protesting the pipeline construction had been consulted sufficiently that their claims or contestations would not amount to a veto over what's happening on their lands, and that economic activities like the Trans Mountain Pipeline were decidedly in the best interests, echoing already the colonial sort of articulation of reconciliation that has been kind of pushed through the courts and structures the whole terms of negotiations between Indigenous peoples and the state. In such a case, I think that that form to reconciliation, which is definitely hegemonic in a classic sense, is undermining the two righteous forms of reconciliation that I would like to see happen not only for my mother's well-being, for the well-being of our communities who are trapped or ensnared in this relationship with Canada and settler society. But those two righteous forms of reconciliation are being overrun and overdetermined by a reconciliation that is just simply in the interest of settler capital and a racistly informed sovereign state. Leave it at that.
Okay. Ni start out skina. Ni tsepe kane ekwan. Ki ni tawa ki no tsepa mapes. Lesik taksita ki tammok suana ki tsepo se no ni tsitape skrakum maskwem. Yeah, and ni tsitape ni tawa ki no tsepa mapes. That's how you would say in Blackfoot. I'm an archaeologist. Mapes would be the equivalent of the archaeological record, and Awakinots would be searched through the things left behind by old people. So I started my career in archaeology in 1980. Yeah, I was just a toddler then. And you know, since I first started my career in the study of the material culture left behind by my Piikani ancestors has always been the motivation for my own research. And, you know, started off in 1980 just as on an archaeology crew, and eventually I went through, I studied it formally. I got degrees in geography and archaeology, And in 1988, I was fortunate enough to receive a fellowship from the Smithsonian Institution to join their curator of North American archaeology at Stuart Cattle Guard site in Alamosa, Colorado. It was a very interesting and very early site, about 11,000-year-old bison kill site. And this is the kind of stuff that really appeals to me, you know. It's my idea of archaeology. We had our base camp at the Great Sand Dunes National Monument in the San Juan Valley. And those were part of the crew that the white guy with the beard was Dennis Stanford. He was the curator of North American archaeology, and I worked for him and his crew, and learned a great deal. And it turned out, as soon as I got back to Canada, I applied to graduate school at Simon Fraser University, where I did a master's degree. And when I first came out here to start working in archaeology, one of the first jobs I got here, you know, I still had to work and earn a living, and so I got a job on a crew on Gabriola Island, where I went and helped excavate a cave burial, and it was about 2,000-year-old cave burial. And a very interesting site, you know, because I had never, first of all, never excavated in a cave before. It's like working under a table, you know, it's like, and it's dark all the time. But that's what I like, you know. Yeah, so 40 years later, you know, here I am as a professor of First Nation studies, or Indigenous studies, but my training is in archaeology, and that's the kind of work I still do. So when I was originally appointed to the faculty at SFU in the Department of Archaeology, I had begun to focus on historical archaeology. Although my ancestors had settled on the Piegan Reserve in 1880, of course none of them spoke English, none of them could read or write, so there's no perspective on their side of what the no historical accounts. So what I was, you know, being an archaeologist, you know, writing history, that's just optional. You know, we can extract history from unwritten sources. And so that's kind of what I began doing my work on, was just looking at the archaeological footprint left behind by hunting, gathering people who suddenly became farmers. I began this project in 2006, which was before, you know, residential schools had appeared on the public imagination with the apology by the Prime Minister. But, you know, this was, it turned out one of the salient parts of my project was excavating the Victoria Jubilee Home, which was established in 1897 when Queen Victoria was celebrating her Diamond Jubilee. So that's why the Victoria Jubilee Home was opened. And the monument that you see there, that's the plaque on it, the Victoria Jubilee Home for Indian Children. And as a result, you know, I worked at this, but one of the things I had told the band to help kind of get my project through was that I would make a documentary about my work there. So I filmed it and made about a 40-minute documentary, which I posted on YouTube. If you want to check it out, it's called Digging Up the Res, you know, and it's just the residential school was only one part of it. I had my own priorities, you know. Since this work was unprecedented at the time, you know, doing historical archaeology on an Indian reserve, I had defined priorities that were more about my own research on institutional spaces in my community. So if you just, the site where the monument is, that's what it looked like. The black and white photograph is what it looked like in the 1890s when it was first built. And the color photograph on the side does a couple of my graduate students and our little calico cat who adopted us for her humans. That's what it looks like today. So we did a number of things. You know, like for one thing, we did a radiometric survey to help us determine whereabouts on this, you know, this photograph. We have none of the buildings or anything like that are there, but using this radiometric survey, we were able to find the old foundations of these buildings, any places that were disturbed. So we were able to narrow our focus down on whereabouts it was. And yeah, we were somewhere in front of those, the school buildings. So as a result of this work that I was doing on historical archaeology, I received an invitation from the Truth and Reconciliation Commission in 2009 to help out with its Missing Children's project. And I was hired, and I worked with a lady named Alexandra Moss. She's also an archaeologist. And actually, we were in graduate school together. So when she was working for the TRC, she recruited me to help out in this role. And she's now been hired by the federal government to oversee how they're responding to the calls to action. So that's Alexandra and I. This job that I took on took us to various parts of the country, right down to Shubenacadie in Nova Scotia on the east coast, and also up into northern Ontario to Sault Ste. Marie, which is where this picture is at Algoma University, at Sault Ste. Marie, which was formerly a residential school. And you know that main building you see there, that was the residential school. It's now been repurposed to a university. Chief Shingwak, who was the Anishinaabe chief, who was the inspiration behind what he called the teaching wigwam, inspired this school. And it was very recently repurposed as Algoma University, although they have a large archive there dedicated to residential schools, which the director had started developing back in the 70s. And there's a small cemetery on that campus, you know, where students from that time were buried. And, well, the history of residential schools is just a chronicle of tragedy. From the archival evidence, you know, we discovered that at least 4,000 children died and were buried on school grounds. And we know from looking at architectural drawings that they were anticipating kids were going to die there. They even identified places where on the schoolyard they were going to put the cemetery. So it was something that was very, they were aware that this was happening. And then today there are abandoned cemeteries all across the country. Because when these schools were decommissioned, the land was just subdivided into plots and sold as fee simple property. Therefore, some of them are on agricultural lands, and some are municipal parks, some are in housing developments adjacent to cities, and some, like the cemetery in Chapleau, Ontario, was just abandoned in the forest, you know, and it cries out for some kind of remediation. I also had a chance to visit Mount Elgin Industrial School. This was ground zero for the whole residential school project in Canada. And Mount Elgin is a few miles southwest of London, Ontario. It was ground zero for residential schools when it was built in 1847. And children from across Ontario and Quebec attended until it was closed in 1946. And we know a lot of children died at this school. Today, like that old pig barn, that's the only structure that still remains from the industrial school. It's located on the Chippewa of the Thames First Nation. This is a small reserve, so they don't have a lot of land to, you know, do these things. Every square inch seems to be used for residential development. So this is a small reserve, so the original school grounds now contains housing for band members. So this old pig barn is the last remaining structure. However, the community did set aside a few acres to commemorate and memorialize the site, which is a beautiful area. And you go there and see. They have that's on the left-hand side, the fellow, and that's Alexandra Moss. We were at the memorial site at the Mount Elgin School, and they have several of these obelisks around the perimeter of the area, and it has just all the names of kids who attended that school. Not all, you know, like not all of them died there, but kids who attended school there. And one of them is left blank for missing kids. Another place that I had a chance to visit was at Spanish Ontario, which is on the north shore of Lake Huron, just a few miles east of Sault Ste. Marie. And in this case, the cemetery that was associated with the school, there were two schools there, a girls' school and a boys' school. And when we came across it, they had this monument there because the cemetery from the school actually ended up becoming the cemetery for the whole community. There is a small section in one corner where all the kids from the school were buried. There's no gravestones or anything like that, although all the priests who died there, and they all had headstones. One of the more poignant parts of this was the monument, which there are names on both sides of it, but it was so evident that the Spanish flu epidemic had struck this community and this school in particular. And just by looking at the names on the monument, it was very evident that the outbreak started in the girls' school, and then it ended up persisting a little longer in the boys' school. So I just wanted to specifically point out, where are we now, asking that question? The call to action number 74, which calls upon the federal government to work with the churches and Aboriginal leaders to inform the families of children who died at residential schools of the child's burial location, and to respond to families' wishes for appropriate commemoration ceremonies and markers and reburial in home communities where requested. So that brought me to this project that I'm currently working on in Brandon, Manitoba, the Brandon Indian Residential School. Back when the federal government, Canada, was signing treaties with the Native people in the plains, one of them was Treaty 5. And in Treaty 5, there was a stipulation in there that the federal government was going to offer, bring schools to the communities, or education to the communities. But it turned out that was such an expensive option, having all these schools located. So instead, they did was to create one school in Brandon and to bring all these children in from across northern Manitoba to the Brandon Indian Residential School. So the original school, which is the one on the lower picture, lasted from 1895 to 1929. And then it was replaced by the more ominous, imposing structure. In this one, the school was a dairy farm with 920 acres, and children recruited from the Prairie provinces plus Ontario and Quebec to be the labor force that kept the farm a viable operation. And yet survivors always talk about the poor quality of the food and the constant hunger that they experienced. Vocational training and farming continued until 1955, when the farm ceased operation and the livestock was sold. The school continued to operate, and more children attended there until 1972, when it was closed. During those last years, the focus turned to full-time academic training. So when the school was decommissioned in 1972, it stood for a few years before it was torn down. The original 920 acres were divided into smaller sections and sold as fee simple land, whereas the school once dominated the countryside. Today there is no visual reminder that there was once a school here. There's nothing to there. That's what's left. The physical structure was dismantled, and today there's only a pile of rubble around the old foundation where the school stood. So the Sioux Valley Dakota First Nation is the closest Indigenous community. They are concerned about the abandoned cemeteries associated with the school, and they were the ones who instigated this whole project, because they invited me to come and help out with that area. Archaeology, that's kind of what we do, So I see archaeology has a significant role in achieving results for this call to action. Archaeology can deploy forensic methods to retrieve information from the landscape. So we are in a unique position to contribute our expertise in areas such as skeletal analysis, oxygen isotope analysis, and DNA analysis to find missing children and to reclaim their identities. So that's what Canadians are looking for, is searching for some form of reconciliation. And the residential schools and missing children offers a very tangible approach, to finding some, I hesitate to say it's going to lead to reconciliation, but it'll bring it to our proximity. The Brandon Indian Residential School will be the first of its kind in Canada. Our team will conduct a forensic investigation of an abandoned cemetery. We will exhume graves to determine age, gender, and cause of death using physical anthropology and archaeological methods. Our ultimate goal is to repatriate children to their home communities. And this is how, my own thinking about it is how we're going to use all of that, because we have 3 data sets, the forensic data, archival documents, and also oral histories. So these are all the sorts of things that I do anyway with historical archaeology. The forensic part is a little bit new to me, so I'm leaving it to the experts in our consortium. But each source of data augments the contents of research. Studying them contributes methods that can create a clearer picture. And this constellation of data sources will help us reclaim identity. The Sioux Valley First Nation will become the living representative of the children until families can be notified and the remains repatriated. Unlike other calls to action, numbers 71 to 76 are not abstract at all, and we have a tangible metric by which to measure our proximity to reconciliation. Yeah, too many families have been waiting too long to find out what happened to their children. And so we are now in a position to start bringing some answers and some closure. So I just want to first acknowledge the people are involved in this, the Dakota Sioux Valley, Dakota First Nation, in particular Elton Taylor, who has been our lead there. And our research consortium includes Catherine Nichols, who I am supervising for a PhD. She'll be the first person who will get a PhD in Indigenous Studies at SFU. Hugo Cardoso, who is doing the physical anthropology. Dongya Yang is our DNA specialist. Emily Holland, and there's one more person whose name I forgot to put here, John Albanese from the University of Guelph, who are also physical anthropologists. This project is supported by a grant from the Social Sciences and Humanities Research Council. Thank you.
Thanks so much to Alison and Eric for inviting me and all the work, and to my co-panelists. It's so great for me to have an opportunity to learn a bit about the Canadian processes. I'm going to talk a bit about South Africa. So, following our first democratic elections in 1994, South Africa established the Truth and Reconciliation Commission through an act of parliament in 1995 as one of the ways that the new state was trying to respond to its brutal past. There are a number of different views on the TRC. Here are 2. The TRC was a groundbreaking, morally innovative response to an incredibly difficult problem, expressing restorative rather than retributive justice. The TRC was a morally problematic compromise which let perpetrators of atrocity and injustice off the hook, romanticized forgiveness, and did nothing to address the legacy of apartheid. I think both of those are roughly true, although not both exactly true, and I'll talk a little bit about that. So the TRC had 4 main structures. It had an amnesty committee, a victims committee, and a reparations committee, and also importantly, a mandate to produce a report. It also had actually, and this is the only bit that is still going on, a missing persons task force, which was charged with locating and identifying missing activists, or the bodies of missing activists, and exhuming bodies off and doing DNA analysis and giving them back to their families. That work is still, everything else was wrapped up a long time ago, but that work is still ongoing, and they're actually doing really amazing things there. So the Amnesty Committee considered applications from individuals who applied for amnesty for politically motivated atrocities committed during a specified period. So if they got amnesty, they didn't have to say sorry or express regret. They just had to give a complete account of what they'd done, and then they could get immunity to prosecution. If you didn't go to the TRC and apply for amnesty, you could potentially have been liable to prosecution later on. The Victims Committee, or the Human Rights Violations Committee, investigated human rights abuses that occurred between 1960 and 1994. Both of these 2 committees traveled around the country for a period of 2 years. So they had hearings in multiple locations, town halls, villages all around the country. The Reparations Committee was charged with investigating ways of restoring victims' dignity and formulating proposals to assist with rehabilitation. So the TRC, as I mentioned at the beginning, was often spoken about in terms of the rhetoric of restorative justice, but it's very contested exactly what restorative justice is supposed to be. It's described in a lot of different ways. Sometimes it's described in opposition to retributive justice, which is associated with punishment, sometimes in terms of particular kinds of processes or procedures, and sometimes in terms of the values restorative justice is said to respond to. So a central version of restorative justice involves non-adversarial face-to-face meetings between perpetrators and victims, which are usually a diversion from the criminal justice system, and which are said to aim at repairing harms and promoting reconciliation rather than punishing. And in the South African context, it was often associated with the value Ubuntu, which roughly means humanness. It's understood in terms of its role in the expression Umuntu, Ngamuntu, and Ngabantu, which means a person is a person through other persons. And Archbishop Emeritus Desmond Tutu, who is the chair of the Truth Commission, certainly spoke a lot about Ubuntu and its role in restorative justice, saying with restorative justice, the central concern is not retribution or punishment, but in the spirit of Ubuntu, the healing of breaches, the redressing of imbalances, the restoration of broken relationships. So I've mentioned that restorative justice is often understood in opposition to retributive justice. It's also debated what retributive justice is. Some people simply see it as expressing vengeance and therefore as a very suspect kind of thing. But retributive justice is also argued to respond to important moral concerns, including condemning wrongdoing, holding perpetrators accountable, and upholding the rule of law. Now, one can, of course, debate whether punishment is the best way of doing that and what forms of punishment are morally permissible, but I think at least the last three are important moral aims. So, did the TRC exhibit either of these two things in either way? I think it's a complicated question because there are multiple forms of both. So, amnesties were obviously an alternative to a Nuremberg model of prosecuting individual perpetrators. Instead of prosecuting the apartheid leaders, like the Nazi war criminals were prosecuted, we were having a process which enabled people to get complete immunity from prosecution. But this isn't typical of restorative justice models. Most restorative processes don't involve just letting perpetrators off the hook. There's supposed to be some kind of acknowledgement and process involving the perpetrators, which there certainly wasn't in the TRC process. This is one of the things that one of the reasons that some people thought the process was morally problematic, is that they thought that by giving perpetrators of atrocities amnesty, that this was inconsistent with the requirements of justice. And in fact, Steve Biko, the famous activist who was tortured and murdered in police custody during apartheid, his family took the TRC to the Constitutional Court, arguing that it was inconsistent with their rights to get accountability from the perpetrators of that atrocity. There was a lot of talk around the TRC about the idea of forgiveness. This is kind of a complicated question because it wasn't part of any of the official framing of the TRC or any of its official structures. It wasn't a forgiveness commission. On the other hand, Tutu's Christian leadership did bring the concept of forgiveness into the TRC a lot, sometimes in very problematic ways. Critics of the TRC today, particularly a new generation who look back very critically at the leaders of the negotiation period and often say, well, the Mandela generation were too concerned with forgiveness, they sold us out, we should have had justice. They often think forgiveness played a big role. I actually think that's kind of questionable whether it really did. One of the ways the TRC was justified at the time by people who thought that we were giving up on justice by having amnesties was that it was a compromise. We were sort of compromising. We weren't meeting all the requirements of justice, but we were doing that in order to get at the truth. And it was certainly the case that there was an enormous amount of information that would have been very difficult to get at in the absence of this process. So apartheid was a systematic and long-standing severe injustice with many facets, But in addition to the official doctrine of apartheid, the apartheid government had multiple covert operations that were engaged in, by the standards of the apartheid state, illegal atrocities, including illegal and unacknowledged, officially denied cross-border wars in neighboring countries, and kidnapping, torturing, and murdering activists. And it was going to be very difficult to recover that information. As soon as the negotiation period started, leaders were shredding documents, apartheid leaders were shredding documents, and by giving people an incentive to come forward and reveal that information, we arguably uncovered a lot more of the details of the apartheid past than we would have had we just attempted to have a few high-profile prosecutions. And while one of the many disappointing features of the TRC was that very few, in fact no apartheid leaders really took any accountability, and none of them were really held accountable by the process. But the amnesty process gave apartheid's foot soldiers, as it were, the operatives who actually carried out the abductions, murders, and kidnappings, an incentive to come forward and give information about what happened, which did reveal an enormous amount about what happened and its links to the state, and enable, so the top images of Eugene de Klerk, who led one of the, was nicknamed Prime Evil in South Africa for a while, who led one of the farms where missing activists were tortured and murdered. And that did create a link to the apartheid state, and that did give a lot of information. And of course, if you're going to have prosecutions, which would have been an alternative model, you need information, and it's not clear how much information we would have been able to get without the amnesty process. It was a disappointing feature of the process that it was primarily the foot soldiers and not the leaders who came, but that did actually mean that the people who had actually murdered people were giving the information about, for example, where their bodies were, which might have been very difficult to obtain. So one justification people give for retributive justice is to condemn wrongdoing, and finding out the facts is the necessary part of that. So I think to the extent that the TRC was trying to get this information, that's not necessarily in tension with at least that ground of justice. And it's also important to remember, I think especially for the contemporary generation who think that the leaders of the negotiated settlement sold them out, and that Mandela's generation talked too much about forgiveness, which I think actually isn't true about Mandela himself. He was very careful and certainly didn't always talk about forgiveness. But when people think that they were sold out by the settlement by leaders who were too worried, too focused on forgiveness and not enough focused on justice, it's important to remember that the commitment to have an amnesty wasn't something which the post-apartheid state decided when they were designing the TRC. It was committed to in the negotiation process as part of the settlement. So, and it's also, it's hard sometimes to remember, but I think really important to remember what a knife edge South Africa was potentially on at that point, and that the negotiated settlement, compromises that it involved looked really worthwhile at the time. So the framers of the TRC weren't deciding to come up with amnesty. Rather, they were working within a framework in which they were committed to amnesty. And within that framework, I think they actually did a reasonably creative job, because we didn't have, for example, the Chilean solution of a blanket amnesty behind closed doors, which could have been one of the ways of interpreting the settlement, the negotiation commitment. Instead, we had public and entirely individualized amnesties. So individual people had to come and say what they'd done if they wanted to have a chance of getting amnesty, which is it's less than what some people want from justice, but it has more potential for accountability than available alternatives, given that there was an agreement that there would be amnesties. The victims' forums, I think, were closer to a standard restorative justice model. One of the things that defenders of restorative justice appeal to is that in criminal justice proceedings, victims are only present as witnesses to be cross-examined in an adversarial process aimed at establishing guilt of the perpetrators. In restorative justice processes, and certainly in the TRC forums, the victims were present in their own rights, telling their stories. And that was just in itself an incredibly important counter to the official apartheid narrative. And there is, as previous speakers have both mentioned, that is an incredibly important part of a process when you'd had the narrative that you'd had. And again, it's hard to imagine in the internet age, the pre-internet age, and the stranglehold the apartheid state had on an entirely censored press. Books banned. When I was growing up, the press wasn't even allowed to indicate the extent to which it had been censored by printing black pages. You know, and the state had complete control of television, which, by the way, was only allowed into South Africa in 1976. Interesting fact. So the victims' forums played an important role in replacing that official narrative. This was a public process from the state. All the suffering which had been denied for years was being acknowledged, and many of those hearings were incredibly moving and powerful, and people did talk about it as restoring their dignity. A massive problem with the victims' process was that the way the TRC was set up is that it was victims of atrocities that could come to the TRC. So it was victims of acts which were illegal by the standards of the apartheid government. That's a pretty low bar. So most South African victims of apartheid were not victims by the standard. So the process in a way wasn't really focusing on apartheid as the wrong, but rather on atrocities of the apartheid state, and also some of the liberation movement. The Reparations Committee, the TRC itself made amnesty decisions, but it didn't make reparations decisions. Rather, it had a committee which came up with recommendations. This was another problem because perpetrators got amnesty immediately, whereas victims didn't walk away immediately with anything, but waited rather a long time. The TRC made recommendations for amnesty, for reparations, which was just mostly a financial payment, although there were also some monuments and symbolic acknowledgements. The government overturned a lot of the recommendations that the TRC made. So the government reduced the amount of money that they'd recommended, and the TRC had recommended a one-off apartheid tax on white South Africans as well as on business, and the government chose not to implement either of those. And the reparations that were made to individual victims of atrocities were pretty minimal in relation to their needs, and they weren't individualized. It was just a standard amount of money. So I've mentioned that defendants of restorative justice say that it gives expression to better values than retributive justice. But there are lots of problems with restorative justice. One question is, critics argue that it's not a form of justice at all, it's just prioritizing other values. The non-adversarial nature of confrontations between victims and offenders can be exaggerated and romanticized. Restorative processes typically exist with courts as a backup and often depend on that. Non-adversarial restorative processes don't respect due process, which is potentially a problem, so they can't be used to establish guilt. Requiring victims to reconcile with those who've harmed them may be unfair. If perpetrators have to meet the needs created in victims, this will disproportionately burden poor perpetrators, which is also a problem of justice. And restorative processes seldom actually meet the actual material needs created by harms, and can create false hopes, which can result in further harm and resentment. And some critics argue that they can lead to not paying attention to other values, like condemning wrongdoing. So I mentioned that a justification given for retributive justice is condemning wrongdoing and holding perpetrators accountable, and some forms of restorative justice, I think, can do this. So I mentioned that in the South African case, it would have been incredibly difficult to prosecute those at the top, and we did have evidence of that with 1 or 2 trials which had been attempted. So, for example, apartheid leaders were very careful to use instructions like, this activist needs to be permanently eliminated from society, which they claimed didn't mean kill. Apartheid operatives carrying out their instructions didn't have any doubt what the instructions had meant, but that was just one of very many ways in which it was going to be difficult, given the chain of command, the shredding of information, the complexity of the information and the lack of witnesses, to really prosecute the leaders. But if the amnesty process was the condition of making the details of atrocities known, it was a condition of condemning them, and as I've said, amnesties did uphold the idea of individual accountability. So I think that there are ways in which restorative processes, depending on how they're framed, can actually respond to some of those concerns I mentioned, and also some concerns with about neglecting the concerns of retributive justice. Another thing that was, I think, an innovative and helpful function of this TRC process was that if we had only had perpetrators of individual leaders, or more likely perpetrators of individual foot soldiers, because that was the people who were more liable to actually have evidence against them come up and be prosecuted, concerns of justice might say it would be kind of unfair to prosecute the foot soldiers while not prosecuting either the leaders or the complicit white South Africans in whose names these atrocities were done. So there would have been some concerns of justice by just prosecuting a few people. In the process that we did have did enable some individual accountability, but at the same time a report which was able to make findings that went beyond individual perpetrators. So looking at the society as a whole that had enabled apartheid to flourish. I mentioned that the reparations were inadequate and not individualized, but I think that even if there had been bigger payments, it was just a monetary amount, and that would never have undone the harms. But I think that symbolic reparations can play a really important role, including a role in condemning wrongdoing. And so I think that one of the problems with restorative processes, or at least with this particular restorative process, is that we need to see clearly what reparations are doing. If reparations are clearly seen and expressed as being symbolic, as expressing the value of victims and condemning wrongdoing, they're less likely to be wrongly mistaken for actually repairing the harm done, making it more clear that other steps need to be taken to do that. So the way the process was framed was that the reparations were supposed to be meeting victims' needs. Had the framing more clearly been that the reparations were symbolic, there would have been more pressure on having other processes to meet victims' needs. And I think the reparations probably can't do both. They can be either symbolic or really meeting people's needs. So retributive justice, I've mentioned, is defended as condemning wrongdoing, holding perpetrators accountable, and upholding the law. Depending on how they're thought of, restorative processes can also be used to condemn wrongdoing, including by upholding the value of victims and holding perpetrators accountable. Of course, it's extremely complicated in the apartheid case and in the residential schools, where the state or the rule of law itself was responsible for the wrongdoing. Then, of course, there are difficulties with the idea of using punishment to uphold the law, which are often situations in which restorative processes might have a better chance. So I think that restorative justice is most likely to work well where we don't overestimate what it can achieve, so we don't mistakenly think that in having a restorative process, we've done what needs to be done to address the wrong. The TRC process never had a chance of making up to the victims of apartheid, and nobody should ever have thought that it's a failure of the process if it couldn't do that. Many of the problems and justified criticisms, some of them are intrinsic to the TRC, but I think many of them may rather be a function of expecting it to do more than it could have, so neglecting other needed responses to wrongdoing. And some of the problems weren't intrinsic to the TRC process, but rather a function of subsequent state failings. For example, the state didn't prosecute people who didn't apply for amnesty, which it could have and arguably should have done. The other main way in which the state has subsequently possibly undermined the TRC, or at least the possibility of reconciliation, is that we haven't taken the steps needed to redress the material inequalities of apartheid. But the TRC couldn't do that. That would never have been a chance for it. But arguably the justification of the process is somewhat undermined by the failures of the state to achieve this.